Welcome everybody to our last session of our housing management update. So my name is Baljit Azra. I'm a partner within the housing litigation team. Alex?
And I'm Alex Loxton. I'm an associate in the housing litigation team.
Thank you. So this session today, what we're going to be looking at is your repairing obligations. So we're going to cover your repairing obligations insofar as Section 11 of the Landlord and Tenant Act, your express repairing obligations, the Defective Premises Act, the Fitness Act, and the Pre-Action Protocol. Now, there is also the Environmental Protection Act, but we won't have time to be able to cover that. This is quite a short session. The other thing to mention is there's lots of case law that we're not going to be able to cover today as well. Thanks, Alex. So your repairing obligations as a landlord, they can stem from either contractual or implied. Alex is going to talk to you about the contractual obligations, and I'm just going to run through your implied obligations. So the implied obligations that we're going to look at today are going to be Section 11 of the Landlord and Tenant Act 1985. Don't worry too much that I'm talking about Section 11. We will explain exactly what that is. The Defective Premises Act, and also the Fitness Act. There is also the Covenant of Quiet Enjoyment, but we're not going to be covering that today. We'd said that we were going to cover repairing obligations, contractual and implied, and I was just going to cover some of the implied ones. So we've got Section 11 of the Landlord and Tenant Act 1985. We've got the Defective Premises Act and also the Fitness Act. There is also the Covenant of Quiet Enjoyment, but I'm not sure we're going to have time to be able to cover that. Thanks, Alex. So just moving on to Section 11 of the Landlord and Tenant Act 1985. This is one of the most prevalent that comes up in the disrepair claims. And what we've done is just set out the essential part of it, slightly paraphrased, but the most relevant parts are that you as a landlord will keep in repair the structure and exterior of the dwelling house. You'll keep in repair and proper working order the installations in the dwelling house for the supply of water, gas, electricity and sanitation, and also for space heating and heating water. So if we have a look at that definition, if we just break it down a bit, what do we mean by repair? Well, what that actually means is that you're going to keep in repair. So that is from the start of the tenancy right through to the end of the tenancy. What is classed as structure and exterior? Well, when we talk about the structure, we're actually talking about the fabric of the building. We're talking about what actually gives it the appearance, stability, and actual structure itself. The exterior is usually the outside, so up to the outside. So that will include the external walls, it will include windows, floor joists, partition walls, the roof, and if you've got a skylight, it will include all of that. What do we mean by the dwelling house? Well, the dwelling house is whatever you have demised to your tenant. So what is it that you've let to them on your tenancy agreement? So if it includes the house and the garden, that will be your dwelling house. Proper working order, just as it suggests, it's got to be functioning. What are the installations? Well, that means that anything that is directly or indirectly affecting the particular property. So, for example, you could have a block of flats which has got communal heating. That will be heating that is indirectly affecting this particular tenant as well. So when we talk about installations, we are talking about basins, sinks, bath and sanitary conveniences. But what we're not talking about is fixtures and fittings and appliances for the purposes of gas, water and electricity. So for example, we're not talking about things that the tenants could remove. For example, white goods, so that might include washing machine, dishwasher, and potentially a gas hob. Showers is also one of those areas that is worth a discussion as well, and we can come back to that if we have time at the end.
Okay, so following on from what Baljit said there in the definition of Section 11, What we thought it might be helpful is just to have a discussion about what might or might not fall within your Section 11 repairing obligations, and certain items that come up that we see quite often where a tenant might try and bring a disrepair claim against your organisations for repairs to certain items. Now, the definition, as Baldy's just gone through, is on the face of it quite wide, but actually there's been some case law over the years which have helped to define what that actual Section 11 obligations are. And we're going to do a little bit of interaction here. So we're going to have our first poll here. So if you could answer on this one, we're talking about a path leading directly up to a front door of a property. So if we can have the first poll on that one, you should have a poll on your screen which says, does a path leading up to the directly to the front door, is that actionable under Section 11, would you think? So it's a simple yes or no answer. Would Section 11 apply to a path leading up to the front door? Getting some good answers coming in there. So at the moment, overwhelmingly people are saying yes. So at the moment, it's about 80% saying yes, Section 11 would apply to a front door, about 20% saying no. Just leave that for a couple more seconds. Okay, I think it's steady there at about 80-20, yes and no. So if we can end that poll there, so it did end exactly on 80 and 20%. Now, it might surprise quite a few of you to say that actually there is a case that was decided a fair few years ago now that indicates that a path leading directly to a front door does not fall within your Section 11 obligations. Now, the huge caveat there is that it might not, it might fall under other repairing obligations that you might have. But for Section 11, the court said that the exterior of a property is to be given a very, very common sense approach and interpretation. So the court said in the Edwards case that the exterior of a property stops basically at the exterior walls. It includes things like downpipes on guttering and things like that, but actually exterior stops at those walls. So a path leading directly to a front door wouldn't fall within Section 11, but as we'll see in a little while, it might fall in your other repairing obligations. Now, this was a huge surprise to us as practitioners, because we would always say that a front path going up to your front door as your main access to a property would ordinarily fall within those Section 11 obligations. But the Edwards case certainly said that isn't the case at all. So if we get rid of that, a garden path then. So another poll on a garden path, bearing in mind what we've just said. So we've got a path leading up to the front door. Another poll if we've got on there. Again, so would Section 11 apply to a garden path? So this isn't a path that we'd have in mind going from the path onto the front door, so not the main access. It would just be a path leading down the garden paths. So if we've got another poll there or not, I'm not sure if that's going to come up for us. I should imagine, I would hope, there we go, there's the poll on the screen now. I would hope, and which is what is happening, that we might have a bit of a difference of opinion this time round. So this time we've got about 73 people saying no, Section 11 would not apply to a garden path, but about 27 saying yes. Again, it's another case where Section 11 would not apply to a garden path. And this actually used to be how we would advise people previously, is that we would used to say that front path would be because it's a normal access to a property, but a garden path is a bit of an added extra. It's an added bonus to the property, not something that necessarily needs to be used. But again, the Edwards case that we've mentioned from about 4 or 5 years ago now would strengthen our argument that a path in this way would not fall within your Section 11. And bearing in mind that is all we're looking at the moment is Section 11. It may fall within other repairing obligations. So the last one for you, last poll, if we can have that on the screen. So a broken garden fence, which is a beautiful picture, as you can see on the screen there. So would a broken garden fence...
Oh gosh, overwhelming.
Overwhelmingly, people going no at the moment. Yes, it's catching up a little bit. So this is Section 11 again. So would this fall within your repairing obligations? It is pretty overwhelming at the moment. So we've got about 80% saying no, about 20% saying yes. And I think we can end the poll there because absolutely the 80% of us are absolutely correct. A broken garden fence can be seen in a way, it's the same way as a path. If you take that definition of exterior of a property, it doesn't attach. It's not the direct exterior of a property. A garden fence is again outside of section 11. But again, I will caveat that by what we're going to come on to in a moment, in that it might not fall within your section 11 obligations, but it may well be caught by other obligations that you owe to your tenants. But for the purposes of section 11 Landlord and Tenant Act, it does not apply, and there is not a duty to repair your fence, your tenant's fences, if there is an issue there. So going on, one other thing we wanted to mention at this point, which can sometimes cause issues, is decorating after repairs. So we've gone into a property, perhaps there's been a leak from a bath from upstairs, which has come through to downstairs. We've got ceiling damage, we've got damage to decorations. We've gone in, done the works, there's been some replastering required, but there's still that leftover damage to decorations. There is a duty that goes with the duty to repair to also make good after those repairs are completed. So damage to decorations must also be put right. As I've put on the slide there, decorations must be put back into the same condition they were before repairs were carried out. Now, this can leave us in several different situations. You may go into a property which perhaps isn't well kept, and you may have bare plaster walls that were there before the repairs were required. You may have a property that's very well kept, on the other hand, and could be decorated to a very high standard. Your duty to make good has to match what was there before the repairs were required. One of the questions we quite often get asked, well, the property was in poor condition, we were down to plain plastered walls, so what would we have to do? What would our duty to make good be there? And what I always advise is, actually, if you're down to bare plaster and that's what you've had to replaster, what would you want to do to that plaster to maintain it, actually, and to protect your asset at the end of the day? So I tend to suggest that you may want to do some emulsion coats on that to actually maintain the plaster work that you've just undertaken, and actually protect your own asset, even though that's above and beyond perhaps what the tenant had there in the first place. But equally, if we've got a very nicely fully papered room, for example, we need to be able to either put the decorations right or actually offer compensation so that the tenant can decorate that room back to its usual standard, to how it was before. And this is just a little photograph just to sort of give an example of this. Here, this is an actual property that we dealt with a good while ago now. And as you can see on the screen, there was some plaster work that was required to the ceiling here. Now, if you could see down the middle of the ceiling, one part is a quite nice white colour, the other half is not quite so white. The landlord on this particular matter decided just to paint half of the ceiling. The duty to make good would obviously cover painting the whole ceiling and not just painting the one half. That's just a bit of an example of how far that redecoration duty would go. As you can see in the rest of the room, we are down to plain plaster walls here. Actually, you can see it's been slightly graffitied as well. That is the condition of the room before the repairs were carried out. The only works in this room that were required were to the ceiling. So in relation to the walls, as long as none of that plaster work was required because of the repairs that we've done, we don't need to touch that. It was just the ceiling on that one that needed to be looked at by the landlord, and a good standard of decoration and carried out to put it back where it was as well. So that's redecorating following repairs. We've talked about section 11. The next part of where your repairing obligations would come from, as Baljit mentioned at the very beginning, you've got your implied repairing obligations, which were your section 11. You've then got your express repairing obligations, and this basically comes down to, what does your tenancy agreement say? It's very, very important, and I'm sure your organisations will have many different tenancy agreements that are being used at the moment, that you will have some very historical tenants that have been with you for a very long time. You might be on very old style tenancy agreements. You'll have new tenancy agreements perhaps that have come in recently. You'll have many and varied varieties of tenancy agreements. So it's always very important to go back to the particular tenancy agreement being held by your tenant that you're dealing with in any disrepair type situation, because your obligations may well have changed. We've seen over the years express repairing obligations, what you particularly promise in your tenancy agreement to carry out, have been pared back and stripped back to the very minimum. So the express repairing obligations that you offer at the moment may not be as extensive as they once were. So it's always very important to go back to the particular tenancy agreement that your tenant holds to double check what you've actually said and what you've promised you will look after, which is what it says on the screen there. And there is lots of case law, as Baljeet mentioned. We'll only highlight a couple of them today, just in the time that we've got available. So in Welsh and Greenwich LBC, there was a tenancy agreement there that says to maintain a dwelling in good condition. Now that is quite different to what the Section 11 definition is. To maintain in a good condition goes above and beyond what your repairing obligations are in Section 11. And this is where I say it's quite important to check your tenancy agreements for this reason. So on that one, the landlord was held liable for severe condensation and mould growth here, which may or may not have been actionable under Section 11. But because the tenancy agreement says that it will be kept in good condition, that's where the landlord fell foul of their own tenancy agreement and was actually had some liability there. And the Court of Appeal accepted that good condition was significantly more than keeping in repair, which is what your Section 11 obligation is. So this is just a standard type tenancy clause that we would see here. And I've just highlighted on the screen there that this is a term actually taken from a tenancy agreement that we work with quite regularly. And here the landlord has promised in the tenancy agreement to keep in good repair the structure and exterior of the premises. So that's above and beyond what Section 11 says, where you have to keep in repair. And now we come back to that fences issue. So on the polls, we were very much all in agreement to say that fences would not fall within your Section 11 agreement obligation, sorry. But here you can see at clause H of the tenancy clause on the screen, the landlord here has said that they will maintain boundary walls and fences. Now, if that wasn't in this tenancy agreement and there was an issue with the fence, then the landlord may well be able to go back and say, actually, I'm sorry, tenant, but on this occasion, the repairing obligation for your fence actually lies with you. Now, fences, as we all know, are very contentious issues. Problems with fences can cause all sorts of problems. We can have antisocial behaviour complaints arising around them. We can have dogs, for example, becoming loose and moving around and receiving complaints regarding those sorts of things. So often landlords will look at fences and repair them. But actually, would you then consider that you would actually make that a rechargeable repair instead? But if you were looking at a tenancy agreement such as the one on the screen, you wouldn't be able to get out of the fact that you have got an obligation to repair that fence. Unless obviously there's been tenant damage, for example, and then again it could be a rechargeable if there's clear evidence that it is tenant damage that has caused the fence to be in disrepair. So again, very important to go back to your actual tenancy agreements and make sure that you haven't promised something above and beyond the Section 11. Moving on to Val, I believe for defective premises.
So this is essentially your duty of care. And the thing I omitted to mention is when we talk about implied covenants, those are covenants which are implied into your tenancy agreement. And so you can't actually contract out of them. So within your tenancy agreements, even if you put the Defective Premises Act do not apply to us, it will still apply because that clause will be null and void. So that's something I omitted to mention to you. The other thing I haven't mentioned to you is that we are only talking about tenancy agreements. We are not talking about long leases, and we're not talking about licenses either. So Defective Premises Act is, as I mentioned, essentially the landlord's duty of care. And what it actually says is that you will, as a landlord, take such care as is reasonable in all circumstances to see that the tenant and anyone else who might be affected is reasonably safe from personal injury or damage to property caused by a relevant defect. So we've slightly paraphrased that by referring to tenant and anyone else, but it's actually the tenant, anybody else within the household. The landlord cannot be liable under section 4 for injury or damage caused by something other than, something that the tenant was actually responsible for repairing. So just moving on, thank you. So there's got to be, the most important thing here is there's got to be a relevant defect. So the landlord has got to have failed to put right a relevant defect, which has then caused an injury or damage to the property. Now, what's interesting with this particular covenant is that the landlord does not have to know that there is this issue there. It's so long as the landlord ought to have known in the circumstances. And where does this actually come from? It comes from the fact that a landlord can access a tenant's property and does have the right to be able to access that property. That's where this obligation actually comes. So actual notice is not necessarily required. Now, where does this actually apply? So we normally have a number of cases. So just to give you an example of a particular case, if, for example, you've got a stone or paving slab which has been put against the wall by the tenant, would you be responsible for any damage or a personal injury that's resulted from that? The answer to that is no, because the tenant's actually put that there and a landlord could never know that that had actually happened. But the obligation may be somewhat different if, for example, there is a tripping hazard that you ought to have known about. Thanks, Alex. So the home's fitness from human habitation, excuse me a second. Thanks, Alex. So this is legislation that came into effect in 2018, partially came into effect in March 2019. So it applied to just new tenancies, but we've now seen full implementation of it as of the 20th of March 2020. We've already seen this in letters of claim and disrepair claims. So who does this apply to? It applies to all existing assured and secure tenancies. It does not apply to licenses. Thanks, Alex. So what are the headlines here? Well, this is an obligation on the landlord to ensure that properties are fit for human habitation at the beginning of a tenancy, but also throughout the tenancy itself. And again, you can't contract out of this. It also applies to the common areas or retained parts that the landlord has an interest in. Thanks, Alex. So what's the difference between this section and what we already had? Because we already had a section which was about fitness. The previous section I've just set out in the slide, it mentioned house, whereas now it mentions dwelling. It said that the house had to be fit for human habitation at the beginning of the tenancy, just like with the new section, and it had to be during the course of the tenancy itself. The difference was you could never rely on this because of the rent limits. So your rent limit had to exceed, and get this, in London, annual rent of £80, elsewhere annual rent of £52. So you can see as to why it was never used and could ever be used. So that's why we've got the new section that we've got. Thanks, Alex. So it's going to have the same exceptions, just as you've got with section 11. You can't be expected to put a property right if the damage has been caused by a tenant, or if it's been caused by an act of God, flood, storm, or fire, or where, for example, the tenant was actually entitled to actually remove something from the property. You wouldn't be obligated to repair that. Again, you wouldn't be obligated to repair something that is then going to cause you to breach some other obligation, i.e. third party building consents or planning permission. So, thanks, Alex. If we have a look at exactly what this actually entails, so what you're actually doing is you're actually looking at the property and you're saying, does the property suffer from one or more of the following defects? And if so, if the answer is yes, then you're actually saying perhaps it's not suitable, it's not reasonably suitable for occupation. Okay, so there's a whole series of things that are listed within section 10. So the first one is repair. What does that mean? Well, that's consideration to all parts of the fabric of the property. Stability, and bear in mind, all of this is actually coming from the old section 8. because at the moment we haven't, of course, got any case law. Stability is about subsidence. Is it so significant that it's actually causing a threat to the occupants? Freedom from damp. Now you might say that, you know, there might be a little bit of damp. Does that mean that we're going to get caught by this section? Well, what it actually says is any dampness should not be so excessive that it actually causes a threat to the health of the occupant. Internal arrangement. This is about making sure that there is free passage through the rooms, there's not an obstruction, or for example, steep stairways or even narrow stairways. That's something that could fall under this. Natural lighting. I don't see this one as being a major issue. This is just about making sure that there's sufficient windows, there's natural light, and the windows are capable of being opened. Ventilation, again, this is about making sure that there is sufficient ventilation, whether that be by way of heating and or sufficient windows. Water supplies, just as you'd expect, there is a wholesome water supply. Drainage and sanitary conveniences, this is very similar to section 11, that the gutters are going to be fine, there's going to be sufficient drainage and also enough to make sure that the sewage is going out of the property. Facilities for preparation and cooking of food and disposal of wastewater. This is about making sure that your kitchen area, for example, does have surfaces. So there is proper cooking facilities, whether that be a gas cooker or whatever that is. And then the last one, which is something new, which is any prescribed hazards. Now, please bear in mind that when it says prescribed hazard, it doesn't say that they're hazard 1, it doesn't say the hazard 2, it just says any prescribed hazards. And if you wanted to have a look at this, there are actually 29 hazards which are included. And all of those hazards, to be honest, are the above list. So the likelihood is if you've got one of the above and you've got the prescribed hazards, you've got enough to say that it's going to be a property that is unfit for human habitation. Thanks, Alex. So damp and mould. Now, under section 11, we normally say if it's mould and it's due to condensation, then that's not going to be captured by section 11. The difference with the Fitness Act is if you have got a property which is badly designed or there is an inherent defect, then previously under section 11 we would say, okay, we can't do anything about that because at the time it conformed with building regs and therefore that is not a breach of section 11. However, please bear in mind for the Fitness Act, if there is a design fault and or if there is an inherent defect which is causing condensation related mould, then there is a potential that that will fall within the Fitness Act, so long as it's not the tenants that are causing that issue. Thanks, Alex.
Okay, so what I'm going to talk to you about now, having looked at where your repairing obligations come from, I'm sure many of you have been faced with over the last couple of years at least, is an absolutely massive influx in disrepair claims coming into you. So where a tenant is alleging that you are in breach of your repairing obligation for some reason, and they're seeking compensation for that and also for works to be done to put those issues right. We in our firm have seen a massive increase in this over the last couple of years. I was looking at some stats recently, and I think back in 2016-17, I think we possibly opened about 4 proper disrepair files where there were standalone disrepair claims in the year. At the moment, we can be opening 4 or 5 files a week. There has been a massive explosion in this area, and I'm sure a lot of your organisations have witnessed and experienced that. The one thing we still can't work out is why the majority of the tenant advisors that we see are based up in the northwest. So we will deal with tenants all the way down on the south coast who have tenant solicitors based up in and around the Manchester and Liverpool area. What we do know is there's a lot of canvassing on the faithful Facebook. There's a lot of advertising there that is done, a lot of pop-ups that people can click onto. And I think that is probably where a lot of the tenant advisors will get their referrals, is from issues like that. We see the same sorts of people, the same tenant advisors all the time on many of the claims that we see and deal with for clients. The pre-action protocol, and there is a link onto it, that you will receive copies of the slides after the presentation today. So you'll receive a copy of the recording and a copy of the slides. So you'll be able to access this link once the slides come through to you. Pre-action protocol for housing conditions claims, now renamed so it takes into account the Fitness Act that Baljit's just spoken about. Pre-action protocol is part of the court rules. It's there to govern how these claims are supposed to be brought by a tenant or a tenant advisor. It's there for a tenant to use in person or for tenant solicitors to follow. And it's exactly that what it says. It's pre-action protocol. So it tells all parties involved in any type of disrepair claim what they need to do before proceedings are even issued. The very important thing about the pre-action protocol is that it does contain within it a set timetable for when certain actions are to be taken. So, for example, when your first letter of claim comes in, there is a set number of working days within which you need to reply to that. Otherwise, the tenant solicitors can sort of take your silence as non-engagement and can go off on their merry way and start instructing experts when perhaps we don't want to, or don't want to instruct the expert that they might be proposing. So it's very important when you are dealing with these in-house to have a very good diary system to ensure these things are diarised and that responses are sent when they need to be. Now, in larger organisations, that can be in itself quite problematic when perhaps post is being directed to a central office where perhaps the repairs team isn't located, and it takes some time for that post to come through to the relevant person. That is something that needs to be managed in-house by yourselves, obviously, and you need to have some sort of system in place to ensure that any letters of claim that come in do come to the right person as quickly as possible, because that time scale within the pre-action protocol has already started ticking away. The link is there. It's quite easily, just if you pop onto Google and just Google pre-action protocol for disrepair, to be honest, it will come up and you'll find it there. It's a fairly easy read. It's not that very long. So if you are dealing with these sorts of claims on a daily basis, it would be worth it, and I'd recommend having a look at that just so you can see what the timescales are. The pre-action protocol really aims at four main areas. So the letter of claim, which I will come and talk about a little bit in a moment, that is a set, there's a precedent within the pre-action protocol for tenant advisors to use. And you can see what information should be in there, and we'll talk about that in a little while. Also deals with disclosure of documents, and that's part of a major part of the pre-action work that takes place, is us showing the tenant and the tenant advisor what documents we've got and what we might want to rely on if this matter were to go any further. It's going to include things like your repair records are absolutely key, of course. It talks about access, and one of the big issues we come across with some of our tenant advisors is the issue around access, and some people will take a very difficult approach with that. But the pre-action protocol is quite clear in that area, and we'll talk about that in a little while. And also something called ADR, Alternative Dispute Resolution. The pre-action protocol is very much aimed at don't come to court. It is basically what the pre-action protocol is there for. It says do not come to court, try and sort these issues out between yourselves. And court-issued proceedings should be a very final resort. So we'll talk about what that might look like and the sorts of schemes that might be available to you and your tenants to use. So in terms of the letter of claim, the protocol requires a tenant advisor to send out a letter of claim as soon as possible. What a tenant has to prove to be successful in a disrepair claim is, one, that a repairing obligation exists. So either under your implied or your express or any of the other items we've talked about already, they have to prove that you're in breach of that obligation. So you haven't carried out works within a reasonable period of time, and that you knew about them. So the three elements are, there's an actionable disrepair, you were on notice it needed to be done, and that you haven't carried out those works within a reasonable period of time. So the pre-action protocol is quite clear in that the letter of claim needs to be sent as soon as possible. So as soon as the tenant advisor becomes aware of a potential repair issue that needs to be addressed, there's no hanging on to that to allow that liability period to become extended. They need to get that to you as soon as possible so that the ball can be started rolling not only on a potential claim, but also that you're firmly on notice that there is a repair issue there and that you can start work as soon as possible as well. There may, of course, be situations where an initial letter needs to be sent before a more formal letter of claim, and this is for urgent repairs, for example. So if you've got something where there is an active catastrophic leak that is coming through a whole property, it might be that a tenant phones up a solicitor and say, this is happening. You might get an urgent initial letter for them that doesn't quite follow the letter of claim format. But because of the urgent and emergency situation that is being complained of, they are entitled to do that. But if they do, there should be a more formal letter of claim that complies with the pre-action protocol sent as and when that is possible. So as I say, the pre-action protocol sets out the formal information that must be included in a letter. And again, this is one of the ways that we can throw a letter back to tenant advisors, is looking at their information and does it comply with the pre-action protocol? Because we can send it back and say, well, actually, you aren't compliant and we need XYZ information. So it's important to look out for particularly the following things. There should be a schedule of defects attached. I've got on a next slide or so just an extract from an actual letter of claim that we've seen, but they should be giving you a schedule of defects. Now, quite often, as we'll see in the example in a little while, all we will see is the schedule of defects are as follows. Number 1, the property has damp throughout. 2, damp in the kitchen. 3, damp in the bedrooms. 4, damp in the living room, and it just goes on and on and on. That may be sufficient, it may not be. The pre-action protocol actually gives the tenant advisors a pro forma to follow. So you can dig your heels in and say that you want that schedule of defects in a schedule format and not just a list in a letter. Second thing to particularly look at is details of notification. So the tenant has to set out when they've told you these repairs are required. Again, all too often in letters that we see from tenants advisors, we will see a phrase such as, the tenant has advised you of these issues on numerous occasions or on too many occasions to recount here. That isn't good enough for the pre-action protocol. They should be giving you some details as to when calls were made, you know, if there's been inspections, has an officer been round and been able to see the repairs that are needed for themselves, for example. So this should all be in the pre-action protocol letter of claim. So the thing is that the tenant has to set out what the effect of the disrepair has been on them. And this is where it's particularly important to look out to see whether they're raising any personal injury issues, unfortunately. You will all have, no doubt, insurance cover that will be available for you if there is personal injury claimed by the tenant. So Baljeet was talking earlier about, you know, has there been some sort of injury caused by a slab, for example, that has been perhaps loose or left behind somewhere and there's been a personal injury caused? And the tenant is trying to say that is as a result of you breaching your repairing obligations. There may be damage to, you know, a broken leg, broken ankle, something like that. At that point, it is incredibly important for you to get your insurers on board. If you fail to do so, you can compromise your insurance cover, and it might be that actually they will not cover you in those circumstances. So again, when these initial letters come in, please do make sure you are checking for whether personal injury is being raised, and ensure that you are getting your insurers on board if you need to. 9 times out of 10, they won't come on board if it is just a disrepair without that personal injury aspect. If it is there, you definitely get in touch with them. You don't want to compromise in any way your insurance cover. General embarrassment. Has the tenant suffered from general embarrassment? This might be phrases such as the tenant is too embarrassed to have visitors in the property because of its condition. Those sorts of things should be set out in the letter of claim. And also any special damages sought. So that's compensation for economic losses. So loss of earnings, damage to belongings, medical expenses, anything that can put an actual value on, something that can be valued and have a definite value put on it. It also should deal with 2 very important issues, which is disclosure of documents, which we'll look at in a little while, and also instruction of an expert. We haven't got too much time today to deal with instruction of an expert, but this is another very important issue that you should be aware of. After your initial period for replying to a letter of claim, if you do not, the tenant advisor can quite rightly, under the pre-action protocol, go off and instruct an expert, and that expert will automatically become your expert as well in a claim. And that is what the pre-action protocol says. So do be aware that you could be stuck with an expert that you do not want to use. And this is another reason why it's very important to diarise these dates and make sure that a response, even if it's just an initial response at first, is sent to avoid situations like that. So this is what we see as a typical letter of claim. And this is actually taken from one that came in not too long ago. So our client complains of the following defects at the property, and as I say, it is literally a list of damp throughout the property, damp in the living room, kitchen, hallway, bedrooms, extractor fans are inoperable. And the paragraph on notice is, we're instructed that you have received notice by way of numerous telephone calls of the defects. Now, for me, it would be quite easy for me as an advisor to go back to the tenant solicitors on this one and say, well, actually, you aren't actually giving me enough detail here, and this is not compliant with the pre-action protocol. Particularly that part on notice. Again, you've received notice by way of numerous telephone calls. Well, since when? Has this been an issue since 2006, or actually has it only been raised in 2020? Who made the phone calls? Where to? Give me some at least rough dates, even if you can't give me actual specific dates that calls were made. One of the things that I've started doing with our tenant advisors is saying, well, actually, with the technological world we live in at the moment, nowadays, access to your telephone records is very, very easy. If you've had a particular mobile number for a long period of time, we all know you can go back and get your telephone records for quite some time. So actually, by way of disclosure, I ask them to disclose their client's telephone records, to say, well, actually, if you say you've telephoned the repairs line, prove it. I want to see your documents. But this is a typical letter of claim, and it is possible to go back and knock them back and say, well, actually, we need more from you than what you've got in your letter. And that's quite helpful to be able to do that. In terms of disclosure, disclosure is us letting the tenant's advisors know what documents we're going to be relying on. And the main thing that we are going to be relying on nowadays is your repair records. The repair records, I can't stress how important it is for you to have accurate records of not only when repairs were notified to you, when you've gone out and carried out those works, what those works were, but also ensuring that you've got a clear record of no access as well. So if you've gone to a property and it's been carded because there's nobody there, or the tenant has turned around and said it's not convenient for you to visit at that time, even though it was a pre-arranged visit, it's incredibly important to have those records so that you can rely on them if you need to later on in any disrepair claim. As lawyers, I'm sure Baljeet will agree that we are only as good as your documents. Your defence will be only as strong as your documents and your record keeping. So it's absolutely essential to have that there and ensure your records are up to date and complete. So this is just an example of cases that can come to us sometimes. So this is a letter of claim which alleges that there's been damp in the kitchen, utility room and bedroom, and this was first notified in May 2016, and it's still present today, 4 and a bit years later. And this is an extract of the repair records that was received from the landlord. So just considering the allegations are damp in the kitchen, utility and bedroom, and looking at that extract from the repair history there, what can you confirm from that repair history really? And what additional information would I particularly need as an advisor trying to, bat off and defend this potential disrepair claim? I think you can see from that extract there that actually there's not much, if anything, that really relates to damp. And actually this is how the repair records came to me. And it's very difficult to see anything. Now, obviously, these systems are quite common, and no doubt you may look at this and this might be your own system that you're working from as well. Obviously, there's lots of screens that lie behind this with lots more information available, and it's important for us to be able to have that. But as you can see there, the disclosure of that really doesn't help us take this matter very further forward. We've got lots there about, it's actually a flying anti-infestation, there's some water ingress, potentially that's an issue there, but we can't really get into that to see what the detail is. So if you are instructing solicitors to deal with these things, or you've got in-house legal departments, for example, make sure that all of that information is there and readily available, because ultimately we're going to have to disclose this to the other side as well. So it's ensuring that it is all there and your records are sufficient for you to be able to defend these claims. Val, did you want to do access?
Yeah, sure. So Alex has already mentioned that access could potentially be a defence for you where you've not been able to get into the property to be able to carry out the work. But the defence itself is only going to be any good if you've got some evidence of that. And one of the things that we keep seeing in correspondence from solicitors is a standard paragraph. Alex. So this is a standard paragraph that we see in a lot of correspondence, and I'm sure those of you that deal with disrepair claims will look at this and think, oh yeah, we see this all the time. So one of the things that's always pointed out is paragraph 6.3 of the pre-action protocol. And that's always mentioned by tenant solicitors to say that you cannot access the property until you provide us with a schedule of works. What we have to remember is that a tenant has actually signed a tenancy agreement, and therefore there is a contractual obligation that they must allow access to their landlord. But it's also section 11. Section 11 also says you must allow access for any works to be carried out. So in response to that paragraph, it is important that you do respond to that, to say actually it's going to be the tenancy agreement that is going to be take precedence over the pre-action protocol. So the reason why we've actually put this in is really just to say to you that when you get this paragraph, please don't get bullied by it and think that you can't access the property because the tenant solicitors have actually said you can't. You can, and you have got an obligation under your tenancy agreement. There's also mention of an injunction. Tenant solicitors say that we can get an injunction against you because this would be regarded as harassment. It's not going to be regarded as harassment, and what you need to bear in mind is that you can get an injunction against your tenant for the failure to provide access, so long as you've got decent records to be able to show that. So it is very important in terms of making sure that you've got your records. The one thing I would also point out is that whilst we're in this unprecedented time with COVID, you will find that you may have some tenants who will not allow you access because of COVID. Now, they may or may not have symptoms. They may say that actually they're not tested positive, but they don't want to let you in because they're worried. Okay. If that is the case, you do need to make sure that you document that very, very clearly. So, for example, if a tenant has actually said, you know, you can't come in because of COVID, then please do make sure that that is documented. You actually write to them to say that we are very happy to access your property, but we're not able to do so because you've advised us that you're having symptoms or whatever it is, because that will potentially act as a defence for you. The other thing to mention about access, that there has been a very successful case in Liverpool, which is Liverpool Mutual Homes v Mensa, whereby the courts actually said, yes, you can get an injunction where access has been denied, and an injunction was granted together with costs. The other thing to also mention, thanks Alex, is alternative dispute resolution. Now, this is always mentioned in the letters that you get from solicitors to say, we are very happy to engage in alternative dispute resolution. If you look at the pre-action protocol, if you look at one of the paragraphs, and let me just remind myself which paragraph it is, 4.2 of the pre-action protocol specifically refers to alternative dispute resolution. It specifically states that litigation should be seen as a last resort. And it also says that why not use alternative dispute resolution in the following format? Why not use mediation? And if you are a social landlord, the expectation is that the tenant would go through the complaints procedure and or the local the housing ombudsman. So this is something that we do go back to tenant solicitors all the time to say, well, why is it that you haven't followed what's required of the pre-action protocol? And it's quite useful to say that, okay, we will engage in alternative dispute resolution, but please tell us what you've done in terms of using our clients' complaints procedures. What have you done about making a complaint to the housing ombudsman so as to avoid using the pre-action protocol and then taking it a stage further? So as we've mentioned, there is lots of case law, and if we had more time, we could talk to you more about the case law. There's also the Environmental Protection Act, which is about statutory nuisance. Again, if we had sufficient time, we would cover that as well. We normally cover all of that within a day's programme that Alex and I run, specifically about disrepair. And, that is where you get more insight into the disrepair claims that we're getting and the tactics that we would give to you. So, Alex, we've got loads of questions in the chat. So I wonder whether it's worth us just looking through those.
Yep.
So we've got one from Peter Fabian regarding decorating. Regarding decoration duty on a landlord, damp on a wall. Do we have to paint the whole wall so matches? And 2, do we have to paint the other 3 walls? Do you want to take that one?
Yeah, sure. The duty to make good is to make that room, whatever it might be, back into the same condition it was before that repair happened. If it's just one wall, it has to be painted. The whole wall has to be painted, just much like that ceiling that we saw. The whole wall would need to be done, and actually it needs to be done in such a way that it does then match up the rest of the room as well. So unfortunately, if by repainting that one wall, the rest of the room is at odds and it isn't in the same condition it was before the repairs were required, the duty would then extend out to doing the whole room. Sometimes this can cause big issues. For example, if you have a paper decorated room. So obviously, if you do some plasterworks on one wall, unless that room has been decorated relatively recently and that wallpaper is still available, actually you may end up having to repaper the entire room to ensure that it is back into the same condition it was before the repairs were required as well. Sometimes landlords will want to give a decoration voucher, which may be at a set amount. Some policies and procedures will have a decoration voucher that is given for a set amount in these certain circumstances. That may be enough if we are looking at a room that is just painted, but something that has got a little bit of a higher standard of decoration, that probably is not going to be enough if we're looking at decorating a paper decorated room. So it is something to look at, and it can be quite really an extensive duty of redecoration if that room was in good condition.
Yeah, so Alex, really what we're doing is really putting the property back to the state it would have been had it have not fallen into disrepair.
Absolutely. And if you had something in your own house, if you've got one wall that has had to have works on it, how would you want it redecorated back in? Well, you'd want it to match in with what it was like before. So it's absolutely putting it back into the same position it was before the works were required.
Yeah. So Carolyn has asked a question. We find we comply with the protocol, deny, send our repairs report, then hear nothing for 5 months, for example. Then they threaten, they come back and threaten to sue. Any hints how to avoid this? Well, I think the trouble is that the chances are that they don't have any instructions. We get this all the time. The only thing that we can do is actually point to costs, which is within the pre-action protocol, to say that they've got to comply with the pre-action protocol before they can issue proceedings. And the protocol does specifically say about costs that there will be an issue with regards to costs. The other thing that can be done, and I'm sure you'll agree, Alex, is that we can threaten to either strike out the issued claim and or stay the proceedings until such time the pre-action protocol has been complied with.
Absolutely. I've got an application that is very similar going through at the moment, where it was another very similar matter where we'd done everything we needed to do. We engaged with the pre-action protocol, and the particular solicitors on the other side, who will remain nameless, but you probably know who they are if you deal with disrepair, hadn't been in touch with us for over 6 or 7 months. We'd sent chasing correspondence saying, are you still acting? Do you have instructions? Heard nothing at all. And then the next thing that comes through the post box is issued proceedings. Not even oh, sorry, we haven't replied, here's our instructions. They issued a claim. That claim in itself was defective, and at the moment we're waiting on an application from the court to have that struck out. One, because the pleadings themselves are defective, but also relying on the fact that they are woefully not stuck to the pre-action protocol at all. So that is, we're waiting for that to come through at the moment.
Yeah. And then Angela's also asked a question: what do you do when you receive a disrepair claim where you've not previously been aware of the issues, and then solicitors acting on behalf of the other party stop responding to your request for access? What do we have to do to sort this issue? So we've kind of touched on this about access. I mean, I think what we're saying in terms of access is you've just got to make sure that you've got decent records, and really there's no reason why you can't have a similar process to what you have with gas access, where you've got various letters being sent out. If access is not provided, then you look to get an injunction. Agree with that, Alex?
Absolutely, and that's one of the regular problems we come up against, isn't it, Val? That our landlord clients will want to go and do works, but the tenants will turn around and say, well, my solicitors told me that I'm not allowed to let you in. And as we put on the slide, as you say, just as you would go for a gas safety injunction, that ability is there for you as well. We need to be very clear with the tenant solicitors that we don't agree that the pre-action protocol puts a stop on us doing any works at all. We still require access, and that injunction is there if you wanted to go for it. Just as they say that they will apply for injunctions, we can as well.
Yeah, and there's also paragraph, I think it's 7.6, which specifically says a landlord can access a tenant's property in order to carry out work. So really that is something that they ought to, our clients ought to be quoting back to tenant solicitors.
Absolutely, absolutely.
So we've got Hilary West. How are landlords dealing with tenants refusing access because of COVID? I think we've touched on that. Julia Watts, are we responsible for slips and trips on these paths? So that's part of Section 4 of the Defective Premises Act. And because you do, as a landlord, do have the obligation, or at least you do have the ability to be able to access properties, if you know that there is a potential issue, then yes, you can be responsible if you haven't carried out any works to that property. Alex, we've got another one from Gary Finn. Even when we deny liability due to the lack of notice, the tenant solicitors come back with a Part 36. Is this normal practice and a tactic just to pressurise the landlord into settle? Oh gosh, it is.
Oh yes, the definite answer to that is yes. We can deny to the hilt and often do. And it's almost as if the tenant advisors don't read our letter saying we deny everything, and they just come back with, quite substantial Part 36 officers saying, well, we still want, settlement on this, and we still want compensation. So that is very regularly used, and it is, for want of a better phrase, a bit of a bully boy tactic, in that they are trying to get you to back down. And we will all have, in all honesty, situations where we can look at a claim and go, actually, we haven't probably done what we needed to do, and perhaps we have failed on this occasion. And you will look at those and you'll deal with them accordingly. But equally, you'll look sometimes and say, we knew nothing about these repairs, our repair records are solid, and actually we're going to defend this. And simply by just continuing to send repeated Part 36 officers doesn't mean that you need to collapse and roll over for them. And actually the danger, if you do, is that you set a precedent, and these tenant solicitors will see you as a bit of an easy ride, if I'm honest, and put it that way. So actually it is worth taking that stance. Ultimately, you've got to think of the litigation risk. Is it something that is a little bit 50-50, you may be able to defend it, you might not be? Is it something you do want to settle, not from a point of view you're going to accept liability, but just from a litigation risk and a cost perspective? Or actually, are you cast iron on this and say, no, actually we do not know anything about this, we've done what we needed to do and we're going to defend it? So it's picking that right case and whether you're then going to go on and face a defended claim, I think. But yeah, absolutely, it's a tactic used by all of them.
And we do tend to find that these Part 36 offers are really way out. Some of them are absolutely ridiculous. It is worth actually going back to ask them as to how they've calculated their Part 36 offer, because sometimes they are absolutely ludicrous, very, very high. And they are in cases where, as Alex said, you know, the risk isn't actually there. So, you know, it is bully boy tactics, absolutely. The next question we've got is from Chris Hannon. What if the path helps to provide access to a washing line? Alex, I'm not sure whether you're talking about section 11 or section 4. If it's section 4, there is a potential, if there's something wrong with the path, that you could be liable under section 4.
I think that the same applies, doesn't it? It's not going to fall under your section 11 because it is not part of that very defined exterior of the property under case law. You know, that's gone all the way up to the Supreme Court. You can't get much higher than that, really. And the Supreme Court said exterior stops at the walls. So it's not going to fall under your section 11, as I mentioned at the beginning. But that doesn't mean it won't fall under some of your other obligations. So as Baldit says, the Section 4 Defective Premises Act is probably where you may pick up some liability. But again, you need notice of that, whether that is notice given to you directly by the tenant, or actually you ought to have known that there was a problem with that path. So that is a very, for me, important distinction to say. You know, it might not fall under section 11, but that doesn't mean you're home and dry. It could be under section 4, but also it could be under your express obligations as well. You may well say, I think in that tenancy agreement example we saw, that tenancy agreement said that you would take responsibility for paths. So actually you might be responsible under that as well. Yeah.
So there's a question from Jeff Taylor. Do all these cues depend on the extent of the defined dwelling house? I think what we're actually saying is that section 11 is only going to apply to those within the defined dwelling house. I'm not sure I entirely understand the question.
I think I'd need a little bit more, just a clarification on that one.
Yeah. And then Abby asks, what if you were unable to match the decor? I think you've covered that.
Yeah, I think so.
Would the landlord be responsible for repair on items such as that a previous tenant has left, such as the window blinds, curtain rails, if supply of these items were not part of the original AST for sheltered housing? So here, the window blinds and curtain rails, they are fixtures and fittings which are not within section 11. They're unlikely to be within the tenancy agreement, and they're unlikely to fall within any obligations. Alex, you can't think of any obligations they'd fall under?
Wouldn't have thought so at all, not for those sorts of items.
So those would not be replaceable. Would you say you would have to decorate the whole room if, say, you were replastered following DPC? Would you say that you've covered that?
Yeah, I think, yeah, again, yeah, I think the duty would be there to make good.
Yeah. What about flooring repairs? Are we responsible to put back the floor if damaged due to repairs? Absolutely. Again, that comes back to what Alex has said about making good. Natasha, no notice. How does that work under Landlord and Tenant Act where notice is required? I'm not sure I entirely understand. Notice has to be given if it's going to fall within section 11 of the Landlord and Tenant Act 1985.
I think I need a little bit of clarification on the question there.
Yeah, so if tenants are storing mobility scooters in common areas of blocks of flats in breach of tenancy agreement, and the landlord is aware but does not take action, and an injury occurs, could the landlord be liable under the Defective Premises Act? There's got to be a relevant defect, which is what I'd mentioned. I can't see that there's a relevant defect, but mobility scooters, there's just so much that we could advise on that. So, you know, we could be here all day.
Yeah, there could be liability. Yeah, absolutely. There could be liability, but it would fall outside of repair and obligations, because as Baldwin said, that for defective premises, there's got to be a defect that could be looked at, and that would not apply to that situation. But that doesn't mean there wouldn't be liability elsewhere.
Yeah. Do introductory tenancies still have the same protections as secure tenant? I'm not sure whether the question is, does it have the same repairing obligations?
Well, Section 11 would apply to the introductory tenancy the same as the full secure. And again, you'd have your own express obligations that you would have been given in that introductory tenancy. So as far as I'm aware, unless you've got anything different, Section 11 would still apply, and your express obligations may be different in the introductory period. That might be worth checking your own tenancy agreements out, but yeah, it would definitely still apply to introductory tenants.
And Gary Finn makes a comment. I've seen an expert's report stating that the property is unfit for human habitation, even though there was no damp evident. It still could be unfit for human habitation if it falls within any of the other criteria. So, you know, it's quite possible that there was something else, but we'd probably need to know a bit more as to what was found.
That list of items is so wide reaching.
Yeah,
it could be even as simple as something as the layout of the property could say it's unfit for human habitation. That list is so extensive, it can apply to so many different things.
And we've started to see fitness come into the letters of claim already.
And unfortunately, it's one of those things that is very poorly pleaded by the tenant advisors as well. It's often a very throwaway paragraph which says, and for the reasons above, the property is unfit for human habitation. Well, that for me isn't enough. And again, I will knock back a letter that just simply states that and say, well, that is not good enough. It's your claim to formulate. You need to give me more information as to why you say it is unfit for human habitation. It is filtering through, but not in a very well drafted way, shall we say.
Yeah. And also, I mean, it'd be interesting to see how much that is going to impact, given that we had COVID, given that we had government guidance where landlords could not actually go into properties because of the government guidance. You know, when you look at the liability period, you're not going to have a massive liability period.
Absolutely. We've had many examples recently, haven't we? Just that, you know, they are saying that a repair was reported in January of this year, and they're claiming liability. Well, you know, with the greatest of respect, as soon as March came, we had the lockdown where, as you say, there was the government guidance to say that nothing but the most emergency repairs needed to be carried out. We've obviously had a period of catch up and working through backlogs. We're into another lockdown, although it hasn't impacted as greatly. You know, this year is unlike any other. And even if there is a liability period there, what's it going to be? A couple of months at the very most, I would suggest. So the COVID issue and situation is going to be quite important for us to highlight, particularly over this past year, obviously, and who knows what next year is going to be like. But obviously there are legitimate reasons why repairs may not have been carried out. You know, there was guidance to say nothing but emergency repairs. You may have a tenant who was shielding, or somebody in the household might have been shielding. And so it's very important, again, to have very strong records regarding that. And what I find it's always very helpful when I get instructions in from a client is to understand just how your repairs system worked during that period, and when you may have gone back to offering a full service as well.
Yeah. So there's a question about rechargeable repairs. The only thing, I think the question is quite extensive. It falls more into enforcement. So the only thing I would say is that, you know, it's going to be governed by policy, and you've got to have quite a strict regime as to how you recover those recharges, and whether or not you do take possession proceedings. Do you agree, Alex?
Absolutely. Yeah, it's a very it's an issue that's very much defined by an organisation's own policies and procedures, and without following those, we can find ourselves in a little bit of difficulty.
And then just one. Sorry, go on.
No, go on.
Peter Fabian said, do we have to do a rechargeable repairs, e.g. tenant broke the window, took off doors? Yes, rechargeable. Can we leave tenants without a window?
I would suggest that something like a window like that, I think, would probably be well worth actually dealing with and recharging back. It might well be, as you say, that this can be a source of frustration, especially if windows are getting smashed and broken fairly regularly. But with something such as a window, ultimately you've got to think of protecting your own asset as well, especially at the time of year you've got water ingress coming in there. A smashed window is going to cause even further problems. So as frustrating as it may be, I would suggest that it may well be something that you would want to do, even from a point of view of protecting your own asset.
Yeah, and also the security risk of not doing it.
Absolutely. Yeah. I was just going to say, I'm conscious of time. I think we've come to the end of our time. It's great to have so many questions.
Hopefully we've dealt with the crux of a lot of the questions. But this is unfortunately one of those bite-sized sessions. It would be fantastic if we were able to answer all the questions, because this is what Alex and I do day in, day out. So I'm sure that we could answer the questions. It's just time.
Yes, absolutely. It's been great to have so many questions coming in, and I hope everyone's found it really helpful.
Yeah, fantastic. So thank you everybody for joining us. You should receive a copy of the recording, assuming that I did record it, and also a copy of the slides. And do look out for future sessions that we do run.